1, 2, test 1, 2.
Good afternoon. Welcome. This is the second meeting and second public hearing of the Select Committee of the Senate on the Evidence Amendment Bill 2019 in this, the fifth session of the 11th Parliament. This hearing is broadcast on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel ParlView. I am Clarence Rambarat. I'm the chairman of this committee. And I now invite my colleagues from the Senate to introduce themselves, starting on my right.
Anthony Vera.
Good afternoon, Nigel Freitas, member.
Good afternoon, Saddam Hussein, member.
Good afternoon, Hazel Thompson-Ahi.
Thank you. The committee is also supported by the Secretariat provided by the Parliament, Mr. Lucio and Mr. Greenidge. We also have representatives from the Office of the Attorney General and the Chief Parliamentary Counsel to support us. I want to thank the stakeholders who are here and have accepted our invitation to be here. We have today the representatives of the Legal Aid Authority, Legal Aid and Advisory Authority, the Children's Authority, and the Trinidad and Tobago Prisons Service. We also have the representative from the Justices of the Peace Association, and I thank you for coming. We have received written submissions from the Legal Aid and Advisory Authority, the Prisons Service, and the Children's Authority. We've invited the Justices of the Peace Association, not in respect of a written submission that they have given us, and we would not ask you to make an opening statement, but we'd ask you from time to time during the proceedings your opinion on matters that would arise, because we know that the Justices of the Peace in this country play a particular and very important role in criminal procedure. And we believe that you would have an opinion based on your experience on matters that you may hear while you are part of this session, or matters that members of the committee may direct to you. So I would not ask you, Mr. Ascarali, to make an opening statement, but from time to time we'll indicate when we would invite your contribution, or you can indicate whether you wish to make a contribution on something that has arisen. I want to invite the other three stakeholders. We've received your written submissions, and I want to invite you to make an opening statement, and as we go along, you'd have an opportunity to take us through the details of your statement if there is anything beyond your opening statement. So I want to invite the Legal Aid and Advisory Authority. We are very privileged, Mr. Peterson, to have you. You are not only the chairman of the authority, but a senior counsel with a significant number of years in the criminal realm, so that we invite you to make your opening submission on behalf of the authority.
Thank you very much, Mr. Chairman, and members of the committee. I don't propose to be long, Mr. Chairman, but what I wish to say, that I wish to rely on our written submission, and I am certain that we will be grilled in some of the areas that we have purported to address in our submission. But what I will say about the draft bill is that I think it's a progressive move. I think it has attempted to a great extent, successfully so, to codify a lot of what has been practiced in the courts to some extent, and it has sought to codify and address some of the areas that are usually challenged by attorneys during the course of a trial. So what is refreshing about the draft bill is that it has assisted in rendering some clarity to the process, some certainty to the process, so that attorneys both for the prosecution and for the defense will be clear as to the areas in which they would be called upon to operate. In particular, it is quite refreshing to see some of the drafting with respect to the identification procedures and with respect to the anonymity orders with respect to witnesses, which we all recognize over time that the fear that witnesses tend to harbor have been very effective in prejudicing the justice system and undermining the integrity of a lot of trials. So I will say that the bill is a good start, and I'm sure by the time it has gone through this committee and eventually on the floor of Parliament, that the end product may be very welcome at the criminal bar in particular with respect to trials and the comfort of witnesses in the course of trials.
Thank you very much,
Mr.
Mr. Peterson. Mr. Dane Clark, who is the Deputy Commissioner of the Trinidad and Tobago Prisons Service. Mr. Clark.
Thank you, Mr. Chairman and members of the committee. First, let me apologize for the non-appearance of Mr. Wilson, the Commissioner of Prisons. He's due to proceed on retirement leave on Tuesday, so he's taking care of some other matters as we speak. From a prison perspective, we appreciate what the bill can do for the Trinidad and Tobago Prison Service. From our perspective, today, the prison opened with a population of 4,117 inmates, which is actually a 16% increase from January 2017. What we expect to happen with the passage of this bill is that we could see a further increase in our population due to speedier trials and what have you. However, what is going to be significant for us is that the remand population, which now stands at approximately 58% of our population, could be reduced due to those speedier trials. As you may be well aware, the remanded inmate population is where we face our greatest challenges. Having those speedier trials would reduce the amount of time spent in the remand prison from an average of 7 years for charge of murder to well over 15 years in some cases. So it is expected that with the passage of the bill and its success, the prison service would see some measure of relief as relates to that, especially as the prison service is better geared towards the treatment of convicted inmates than remanded inmates. So with a higher convicted population, we'll be in a better place to treat our rehabilitation and reintegration programs. So the bill actually impacts us in two direct ways. One is with the anonymity of officers giving evidence, again, due to the fear factor that we've been challenged with, and as relates to the children's authority, one aspect of it in terms of appropriate adult. At the appropriate time, I guess my legal officer would treat with those questions if and when necessary. So thank you for the opportunity, Mr. Chairman.
Thank you very much, Mr. Clark. Mr. Hanif Benjamin, Chairman of the Children's Authority of Trinidad and Tobago.
Thank you, Mr. Chairman, for the opportunity yet again for the Children's Authority to be a part of these deliberation. We see this bill as quite progressive, and more so for us as we have grappled in the last 5 years as the authority existence. Anonymity is a serious and critical area in terms of reporting child sexual abuse and other types of abuses. And so this can further extend the protection to people who wish to make reports, not just via the telephone, but even family members who may come forward and give evidence, whether it is to the police and or to the Children's Authority, this can help us to get people more out there to come forward. This can help us to get family members, community, as well as the professional services. We have a challenge right now where people in the professional, whether it is doctors, lawyers, nurses, social workers, teachers, are afraid to come forward because they don't want to be implicated in their workplaces. And I think this will give us a greater ability to get people to come forward and to share the information. And so we look forward to the delineation today. And so we thank you for the opportunity.
Thank you very much, Mr. Benjamin. Mr. Clark, I'll now return to you. You've made your written submissions in respect of 3 specific areas of the bill. And either you or your legal officer, we now will invite you to make your submissions. We have the written submissions, we've read it. If there's anything now that you want to explain to us or take us through on your written submissions, we give you the opportunity to do that now.
Thank you, Mr. Chairman. At this time, I'll ask Mr. Ferret, the legal officer, to take us through.
So Gavin Ferret, legal officer.
Through you, Chairman. Firstly, I'll go to the issue of the appropriate adult, which is defined at Part 1A, Police and Criminal Evidence of the bill. All right. As the Commissioner of Prisons is the person or the designated authority in charge of rehabilitation centers, he has control of all aspects of the rehabilitation at Trinidad these centers, including those convicted and remanded. All right, and what we have seen in the past is attorneys, and in one case, a police officer would have visited the station to see minors. Now, the issue that we have that the attorneys would come on their own volition to see a resident as we would the appropriate term for them, and would have to turn them back. The reason being is that they would have come without a person who is an appropriate adult, a parent or a guardian. And the issue we are having is that in our legislation, the Child Rehabilitation Centers Regulation, let me quote for you. At section 44 of that, those regulations, it reads as follows. A resident is entitled to receive visits from his attorney at law in the site but not the hearing of an officer of the rehab center. The attorney at law at Part 2, 44.2, the attorney at law for the resident shall visit the resident in the company of his parent, guardian, or person with responsibility for the resident, and an appropriate adult or a next friend. All right, so as I mentioned before, the issue we're having that attorneys show up to the center to visit persons who are under the age of 18. And in those, as we interpret the regs, they must be accompanied by an appropriate adult, a parent, or some other person with responsibility for the child. All right, so that is one issue in our act. So what we need some clarification on from the appropriate body who legislates is whether in fact that a child who's under the age of 18 at our rehab centers is entitled to see an attorney at law in his own right or whether this stands. Because as it is at this point in time, this regulation is consistent with the children's court rules, the judge's rules for children, which speaks to the same issue.
Okay. And then you have also made submissions on Clause 3 and Clause 4. So do you want to take us through those submissions?
In relation to those clauses, our submission that we were in agreement with those clauses as it supports and enhances the bill at this point. That is basically it.
Okay, thank you very much.
Just one more thing I want to touch on is the anonymity orders. Right, we have another issue at the prisons, both in civil cases especially, where officers are reluctant to testify due to situations that arise in the prison service. And we see this as a great help if it could be extended to civil matters, because a lot of the times officers appear in the civil courts in relation to incidents that happen in the prison. So we would like to see if this could be extended to civil cases also in respect of these officers, because it will provide an additional layer of protection for them, and it will encourage them to come and give evidence as if they have this protection.
Okay, thank you very much. Senator Hazel Thompson, I, has a question for the Trinidad and Tobago Prison Service. Member?
Are you saying that this bill is in accord with the judge's rules for children as far as appropriate adult is concerned? Is that what you're saying?
Yes.
But when you look at the judge's rules for children, an appropriate adult does not include the following person, and at 5 it says a person employed at a detention center. Yes?
Yes, I agree with that.
And when you look at the bill, it says 12K. What it does not include, a person employed at a rehabilitation center other than.
Yes.
And one of the exceptions would be a person with whom the child is comfortable. So a person employed at a rehabilitation center other than. So that if you're employed at a rehabilitation center and you're a family member or a person who is well known to the child or a person with whom the child is comfortable, wouldn't you agree that this bill is saying that you can, in those circumstances, be an appropriate adult?
Yes, I agree with that situation, but just from our past experience, that wasn't the case at all, where the child would have been comfortable with anybody at the rehab center, or it wasn't a family member to the child. So just in that regard we are speaking of.
Oh, so you're talking about the history, you're not talking about what is going to happen if this bill is passed into law?
Yes.
Because it certainly makes a difference here now.
Yes.
All right.
Thank you very much. I now want to invite Mr. Peterson, on behalf of the Legal Aid and Advisory Authority, to take us through your written submission. It is very comprehensive. You cover 17 areas, and if there are those aspects of your written submission that you wish to highlight for us, we now invite you to do so.
Thank you very much, Mr. Chairman. So I first wish to highlight section 12A1 with respect to the identification procedure to record the first description of the suspect given by an eyewitness. I just wish to underscore that this is welcome, but in practice now, it is common for the prosecution to disclose the first description of a witness purporting to make an identification. That's standard procedure, but what this amendment will do, or what this codification will do, is to put that first description into a form, and I gather from the working of the bill that the recording of this first description in a standard form would lead to two things: consistency of the recording of the first description, because there'll be a standard established form, and it will be a form that will be disclosed in the normal course of disclosure, as opposed to the present practice where the first description is transposed from the witness's statement into a letter or document and sent to the opposing attorney. There will be a standard form which is welcome, and then that form is signed. What this does is lead to consistency and eliminate possibilities of discrepancies in the description, and also it safeguards the investigating officer against allegations being made that he has tweaked or in any way tampered with the first description given by the witness. So that is a very, very welcome codification of what presently obtains in practice. I wish to follow on to section 12B2, which deals with the identification by photographs. The section speaks about showing a minimum of 12 photographs to the witness to make the identification. One understands the reason for that number as opposed to where you have a live, what I could call a live ID parade where normally 9 persons would be used. The fact that they're using photographs, the number has increased to 12 to give some degree of fairness, a greater degree of fairness where witnesses are identified by photographs. But I think they should, coming out of our work, members of the legal aid team that helped to put the submissions together were of the view that there should be imported a maximum number of photographs within a certain time, because it could lead to, because the witness is using photographs and being shown photographs, the witness could then become overburdened, and it could lead to some inaccuracies or a witness tending to make a positive identification where otherwise he may not have. So there should be a balancing of the amount of photographs when employing the process of identification by photographs. Section 12B also provides for where a suspect has been positively identified by an eyewitness. We recommend in this provision that there should be a specified procedure for movement of photographs. For example, a separate database or ID logbook. But what subsequent to sending this submission in, I had considered that there should be consideration for disclosing the photographs, copies of the photographs used to the defense. So if a positive identification is being relied upon by using the system or the medium of identification by photographs, in fairness, the defense ought to be given copies of the, what I will call the dumb photographs, the photographs that are just put to create the process, that they should be given, if not copies, but access in the form of disclosure to possibly attend and view the photographs. It may not be advisable to send copies because you don't want copies of the photographs that have been used on other persons in order who may lend their photographs to the process to be floating around all over. So what can happen in order to ensure fairness and balance to the prosecution and the defense is to have, as part of the disclosure regime where there is identification by photographs, that the defense be given an opportunity to attend, whether it be at the police station or the Director of Public Prosecution's office at a fixed time, to view the photographs that were used in the photo identification process. I then wish to deal with 12D Roman 2, the conduct of ID parade procedure in respect of investigations are not in any way involved in the investigation. This, again, is a codification of what obtains now in practice. And this is also commendable because it's a practice usually that presently where you're using even the one-way mirror and you line up 9 men and you put the suspect among 8 persons, totaling 9, to have the identification. Usually it's someone of a rank of inspector and up and higher, and someone not involved in the identification parade, in the investigation. because that is to eliminate allegations that the person who has conduct of the identification parade and supervisory conduct did not alert the witness as to the suspect that is in the line. So this is a codification of what, from my practices and my years of experience, I've always found that this is usually observed rigidly by the police service. But it's just a codification of it. So it's welcome and it's commendable. Move on from, I will not deal with every section because it's in the, but section 12AH, Mr. Chairman. Are these with special measures, evidence by video link and witness anonymity orders. This is not new to some jurisdictions, but it's fairly new to ours. But presently, again, the practice has developed and the practice has been employed, and up to over the last 2 months or so, I know of 2 or 3 cases where this has been employed, and over the last 3 years, I know of about 5 or 6 cases where evidence by video link has been employed. I have been involved in matters where we have taken evidence from witnesses in the United States, where we have taken evidence from witnesses by video link in England. It creates some degree of difficulty sometimes with the logistics, but not insurmountable difficulties. For example, some of the difficulties, and I don't think I've seen it addressed in the bill, some of the practical difficulties, and I don't immediately have the answers to how some of those difficulties could be overcome, but I'm sure members putting their heads together will be able to come up with a drafting formula that could deal with it. But some of the practical difficulties that I have experienced with video link evidence is the simple thing of taking the oath of the witness. The witness is in the United Kingdom or United States, taking the oath or the affirmation to give the evidence. Recently, we had that difficulty. No one thought of a simple thing as having a Bible on the link where the camera is on the other side. That was easily overcome. But then there was another matter in which we were involved in, apart from just taking the evidence. The accused, who was granted bail and was abroad and unable to travel for the trial, for the preliminary inquiry in the particular case, was willing to participate in the preliminary inquiry. He was not absconding. So we decided to do the preliminary inquiry by video link. The practical difficulty that arose there is that under the Preliminary Inquiries Act in Trinidad, when you complete the preliminary inquiry and the person is about to be committed, they then have to sign a recognizance. Now, the problem with that is that the person was abroad, we finished the evidence, and the magistrate was about to commit, and it requires the person to sign a recognizance to either take bail at that stage upon committal, because if they were previously on bail, it expires on the committal. So the person was abroad, PI is finished. If the person is committed and the recognizance lapse, then there will be no instrument in the system to compel them to appear. How we got over that with some degree of cooperation by the defense is that we stood the matter down, faxed the recognizance abroad, got the person to sign it, fax it back, and the court treated it and get the person to confirm on the video link. It took some time, and then we had different time zones and that kind of thing. There could be rules that could deal with one to go the way of video link. All those procedures are deemed to be taken orally. So that you can say that, do you swear that you hereby accept your recognizance? You could say yes, and that is recorded, even though not documented, but video link. That could replace the paper recognizance that is usually attendant on a committal. But as far as the video link is concerned, it is fine. The bigger thorny question is the anonymity order. Now, in the United Kingdom, I have been to the Old Bailey and witnessed that witnesses are given evidence from behind a screen. I could see this provision getting some resistance because persons like to subscribe to the old adage that he who accuses, I must be able to see my accuser and all of that. I see no magic in the accused person seeing the person who is accusing him. What he is accused on is the evidence. So there is no gain per se by him seeing the person, because we know from history that some witnesses get amnesia when they enter the court and they see the person who has caused them allegedly harm. So they could no longer, they're not willing at that stage to continue giving evidence. The only difficulty with that anonymity provision is that sometimes an accused person or a suspect may not be aware of the identity of the person who is making the accusation. So sometimes for them to give instructions, for example, they may want to say that that person has a grudge against me for the longest while. But if they don't know the identity of the person, apart from seeing them, they will not be able to give proper instructions. And there will be a case where you will know the person's identity once you get their name, but then there will be some persons you may know by an alias, for example, and you don't know that the person whose name is given in the evidence as the accuser is the person who you know as the alias. So to that extent, that is the only area where I see there could be some discomfort with respect to the anonymity order, but I think in the climate in which we have now advanced, that is a welcome provision, and it's a necessary one in order not to defeat the ends of justice. Now, in our submission, some members of my team had referred to a 1934 case, but I did say to them that we'll put it in because I thought the committee should have the benefit of a wider range of input, not only that of the director chairman. But I have said to my team that we have come a long way since 1934, and the climate in which we operate, we have to be different. We have to do things differently because we no longer operate in 1934. Things have changed. Without me condescending to further particulars on what I mean, I think we all understand why this incursion into what someone may call an incursion into one's rights by having a witness anonymity order, I think it's necessary in the climate now. The bill also deals with identification parades. It also deals with confrontation identification. Confrontation identification is something that is already employed, but in our submission, one member of the team came up with a very helpful proposal which I think would assist. Confrontation identification sometimes takes place where an accused person, a suspect, has declined the avenue to have an identification parade done. In the normal course of things where 8 persons are lined up together with him, making 9, and he's behind a one-way mirror, and the suspect is called to identify him with a representative of the accused present or his attorney and a justice of the peace, as the case may be. Where that is declined, the police sometimes could employ a confrontation identification where the person walks, the suspect is in a room and the witness is brought and he said, yes, that is the person, because the suspect at that stage had declined the fairer process that was given to him. One of the proposals that is being suggested in our submission, where that suspect has declined the established fair identification parade procedure, what can be done in a confrontation is to add other persons into the room that generally looks like him. He doesn't have to participate, he's there, but he's among other people, and the witness coming in could see 6 or 7 persons and pick out that person. It's a move away from the established rigid identification parade procedure, but it's also a fairer process than just a one-on-one confrontation. Because if I could say, Mr. Chairman and members, the identification parade procedures, whichever one is adopted, It generally is designed to try to be as fair as possible and have the person identified as objectively as possible. And whatever systems can be employed over and above even what is provided in the statute. If the statute says 9 persons and they put the person among 12, I can't see a person complaining that you had too many persons on the parade for the person to pick me out. I mean, that is as more objective as you can get. So the parades are designed to, or the identification procedures are designed to lead to fairness. And the more fairness that can be employed, I think the ends of justice will be preserved. Mr. Chairman, could I just check with my colleagues to see if there's anything they wish I should highlight?
Sure. Well, the members of the committee who have been taking a lot of notes,
Yes.
get
Yes.
ready to
Yes.
ask you some questions. Proceed.
My
Senior
members of my
Counsel.
team said that they don't wish me to highlight anything else on the
Okay.
submissions.
I would, at this time, I would invite the members of the committee to raise any questions they wish to Mr. Clark or to Mr. Peterson.
Afternoon, Senator Cox.
I would deal with your last point concerning confrontation, but I wonder how fair it is if others are just put into the room with a suspect. By his body language, I think that person would be easily identified.
That is actually correct, Senator. But the difficulty that I could see an investigating officer facing at that stage is that I have offered you, the investigating officer, I have offered you this established, rigid, tested, objective mode of identification. You have declined it. I could bring the suspect, the witness, to confront you. Probably maybe in a room, seated by yourself, possibly handcuffed to the chair, depending on how inclined you are to make free your escape. In that case, that is the least fair way you can have. But one cannot have the suspect to retard the progress of the investigation. So the next best thing would be what would amount to a group identification. And that way, it's true that the other persons in the room may appear to be jovial because they're free, but the suspect is obviously going to be giving off his body language. But that is what he will have to suffer, having declined the earlier offer of the most objective mode of identification. It's not perfect, but fairness is what they will most likely aim at and hope to achieve.
Senator Hussain.
Thank you very much, Chairman. This one is for Senior Counsel. Senior. Senior is our resident and JSC witness, having appeared in most of our joint select committees. And I thank you for your submissions that you made this afternoon. So I want to look at the thorny issue that you raised with respect to witness anonymity. Now, it's a very special procedure that we're going to put into the Evidence Act. Our Constitution protects us having a right of fair trial. Now, you would imagine that is an exceptional tool that the prosecution would want to use with respect to prosecutions for various matters. Now, the question is whether this special measure of witness anonymity orders should be for all offenses, or should we specify the types of matters in which these orders can be granted? And I say this because in other jurisdictions, you have the order being available for matters of terrorism, for gang-related offenses, and even in some cases of murder. As presently drafted, it seems as though this order, we can get it for almost any offense a person is indicted before or charged in the summary courts. What are your views on that?
First, Senator, thank you, Senator, for the question. Witness anonymity order is a serious thing. It's a clear incursion into what we have come to understand to be our right to know who our accuser is. But the difficulty that the prosecution or the prosecuting arm of the state, if I could speak on behalf of them to the extent to which sometimes I do that, they have been experiencing is witnesses tend to have amnesia. And the Evidence Act attempted to deal with that before by a Section 15 amendment, I think it's 15C amendment,
15C.
where the statement that the witness gave stood as the witness's evidence in chief. So prior to that, it would have been the hostile witness provision where that evidence will come down to almost nil and have very little effect where the witness has departed from the statement. They deem hostile, but once you deem hostile, then you're cross-examined by the person called you and the evidence is of very little value. The amendment allowed that statement to now stand as the witness's evidence in chief. The difficulty with the anonymity, the difficulty with that procedure, why you probably have to go the way of anonymity, is that sometimes a witness really, really would like to support the statement. Because when we go this way of the Section 15, it undermines the integrity of the prosecution's case, and I will explain what I mean by that. If you have a key witness departing and separating himself from a statement that he gave previously, usually the allegation is that the police fabricated that statement. I never gave it, so the prosecution now has to make a Section 15C application, call the officers who were involved in the taking of the statement, and give evidence as to the circumstances under which the statement was taken, to try to show the court that the witness is not speaking the truth when he's separating himself from the statement. But of course, that's a question of fact, and that allegation stands in the case, and there's always that blot against the integrity of the entire prosecution. So what you could find in a jury trial is that any doubt with respect to an attack on a particular aspect of the case going along, the jury would always bear in mind, you remember that key witness? And the first day of the trial, remember he was saying them, the police, and they have been doing this. So that undermines the integrity of the prosecution's case, and which is what no prosecutor would like. Apart from just that witness, it permeates the entire case, the integrity of the case. But when you have the witness anonymity order, the witness will have a bit more comfort in, I know I'm not answering the part about the number of offenses, I'll come into that. The witness will have a bit more comfort in supporting his evidence as previously given, because he would have given it voluntarily to the police. Now, I think we can at least start with serious offenses. And if you get as more, well, I don't ever like to say offenses are trivial, but when you get less serious offenses, you could see witnesses not being inclined to disavow their statements. But with respect to your question, I think at least we should consider gang-related offenses, terrorism, and murder. If we are to proceed
Member
to
Bearer.
listing witnesses, listing offenses.
Proceed. Member Hussain.
It's just a follow-up question, Senior. Now, I appreciate the witness anonymity order, and we could look at specifying various offenses. One issue that still troubles me is that the character of that witness. Because you have witnesses or people saying all sorts of things, making all sorts of wild allegations, and we have to test that evidence eventually. Now, when you look at this, you don't know who the witness is because of whatever grounds on which the prosecution will make the application on. The question I want to ask is that we have seen prosecutions fail in the appeal courts because the prosecutors fail to disclose the character evidence of the witness. How can we deal with situations like that where we don't know the identity of the witness and the defense now being denied the opportunity to cross-examine that witness based on the credibility of their character?
Right. Senator, that's a very, if I could say so, and I say to the greatest of deference, that's a very difficult situation to deal with. It's a very practical one, it's a real one, because you need to attack the witnesses. If the witnesses are witnesses of bad character, the witness can't hide behind an anonymity order to insulate his bad character. But then you have, how do we balance, and that's really a practical problem. It's something that gave me some pause when I was considering that part of the bill. I really don't have the answer at this point, but it's a very, very, very important point to consider. How do you assess the witness's character, as you're entitled to do, to attack the credibility of the witness because of the historical bad character without knowing the identity of the person? And that is the difficulty. I think at the end of the day, we all have to come up with some formula that would allow a balance between the right of the accused to attack the bad character and let us know the nature of the person who is making the allegation against him, and at the same time protecting his identity. That is the balance that needs to be struck to be achieved.
Member Vera.
Thank you, Chair. Director Peterson,
Yes, Senator.
welcome. I recognize you as a leader of the criminal bar,
Yes.
and your voice is very important at this hearing because as chairman of the Legal Aid and Advisory Authority, you are representing the Public Defender's Office. So you speak really on behalf of defenders. Now, thank you again for your very helpful, specific recommendations. In summary, you found that the bill brings clarity in the procedures and measures to be adopted in properly taking evidence, correct? You did indicate you had a concern about what happens if these new procedures are not properly observed or implemented. Could you expand on that?
What we are really referring to there, some of it has to do with resources, because a lot of these, like the video link, for example, in some of the matters I've been involved in by video link, simple thing as bandwidth for the reception keeps breaking up. You have to keep dropping the calls. Sometimes we reschedule, and you have to reschedule venues abroad, and you have to pay for the venues twice, and that kind of thing. We have been locking some of the matters to use some of the consulate offices that we have abroad, but there will be some jurisdictions for which we have no consulate presence. So there have to be accommodation for rooms for witnesses twice and that kind of thing, because simple things like the bandwidth and resources and the quality of the digital and all of those kind of things. So that is what we are referring to with respect to implementation and resources.
And I think you also were talking about sometimes the mismatch between officers, for example, who are supposed to work with their diaries or the station diaries are not showing up in court.
Yes.
What your recommendation would be to address that deficiency?
I have observed, and to be fair to the investigators and the police, sometimes the court system, one can anticipate whether a case is going on, and the present criminal procedure rules will help a lot in alleviating some of the historical difficulties. Sometimes you will go to court and you will see 10, 12 police officers stand up along the wall waiting to get to the prosecutor when the case is called. 10 out of those cases obviously cannot go on that day. If they are to send disclosure, if they are to send the status of their witnesses' statements, the preparation of the statements, the preparation of the file, all of that could be sent in a report by one messenger, if you want to call the persons that, instead of having manpower line up there all day when they should be out on the streets. So you find that sometimes some of the officers are absent, cases are dismissed, or cases they are recorded as being absent, which that record may appear to be innocuous on the occasion, but 2 months, 3 months down the road when the case is called the third time and the record shows he absent twice, it's because he probably worked all night on some exercise, or in the station all night, knocking off duty at 7 in the morning or 8, trying to get to court for 9, or tired, fell asleep, absent. So all of those things are some of the things that we need to address. So those are practical things that could alleviate some of those difficulties. Because
Yes.
with the criminal procedure rules now, with the case management system that now imported into the criminal procedure, it leads to more certainty, so that officers and the prosecutors will know this case is not likely to go on because it has not been trial ready through the process. So that has been less a difficulty lately.
Well, I'm glad you said that, because that is also my own view, that these criminal procedure rules and the recent practice direction should assist.
Yes.
But really, it's a culture change that we need to see.
Yes, and with time, it's getting there. It's getting there.
Another point you had raised is that the Legal Aid Act does not give across-the-board representation for all accused, just in respect of a limited category of offenses and under certain circumstances. Could you elaborate on that and make a recommendation?
A lot of what we are referring to there is the duty council system. Presently, the duty council system applies where there's a council on call. We have a 24-hour hotline system, but that applies only to murder and to juveniles. So a lot of children, when children are detained in stations, they make a call. The police officers, most of them on duties, they have a schedule. They call, a council is assigned during the night, and that council takes care, or over the weekend, takes care of that accused person's rights or the child's rights until the first appearance in court on the next occasion, which most times is the Monday morning. But that could be widened, but then when we made this recommendation, we did not factor in that we have the public defender system, which is moving apace, which is, we have started to roll out. I don't know if you have seen in the papers, we have RFPs out for the facilities and all of that, and we have started interviews for public defenders. So the legal aid system would be virtually divided into the civil, and then we have a whole public defender system akin to something like what we see in the United States. So that is going to help with a lot of that.
Good. And so what I'm getting to, because the witness anonymity orders, for example, have been very controversial.
Yes.
And from your experience and perspective as a very senior defense counsel and as chairman of the Legal Aid Authority, you don't see a challenge. You don't see this as a serious abrogation of citizens' rights. You think that this is a necessary step in the legislation, do you?
It's an incursion into one's rights because one always tends to guard their rights historically as to how they know it to have existed. But societies evolve and we can no longer, for example, one could also put into that the right to silence, where historically you remain silent throughout, but now that is being eroded or they have been reducing the impact, the sanctity of that, in that if you don't, you can remain silent, but if you don't, certain inferences could be drawn and all of that. That's an incursion into that historical right to silence. The thing about witness anonymity is, before we always used to say, who accused must prove and we must know your accuser. But those days, we don't have the comfort of those days anymore. So even though it is an incursion, there will be some challenges. One, we want to consider whether we go fully there or whether we have some case-by-case basis and whether we seek an anonymity order and justify it on a particular case-by-case basis. All those safeguards could be put in place because there will be the case where it's necessary.
But in terms of getting there, would you say that though the witness anonymity order should be a measure of last resort to be used in limited circumstances?
At this stage, that may be the appropriate course to achieve some measure of what we need. We need it. We need it. I will not say we need it in every case, but I have seen cases where I think if we had it, where they had as a prosecutor, I think I've seen cases where if we had it, life would have been easier.
So I just have two more questions.
Yes.
You recognize that it is within Parliament's right to make these changes to the Evidence Act, which traditionally have been features of the common law, do you?
Yes. And
on balance, would you say that the legislation achieves a fair balance?
I think so. I think it's a good draft. Yes.
Thank you very much, member and senior counsel. I noticed Mr. Askarali was paying very careful attention and shaking his head as you got into a discussion on station diaries and before that witness identification. Mr. Askarali, some people, but not everybody in the country knows what role a justice of the peace plays in the criminal trial procedure, particularly that part of it that before the accused is charged. So perhaps you can spend a few minutes just telling us and telling the listening and viewing public the role of a justice of the peace, particularly in the criminal arena, criminal law arena, and also anything that you want to contribute in relation to what has been said today, particularly your interest in station diaries and witness ID and so on.
Thank you very much, Mr. Chairman. First of all, let me thank the committee for inviting Joe Pat to be part of this. A justice of the peace, really, he is one who had to, you sign warrants, you sign summonses, you do ID parades, you authenticate statements, mainly it's that you do. And I was very interested, and I wanted to say this, especially where the ID parade is concerned. I listened to Mr. Peterson, and he was saying that when you do the ID parade with the one-way mirror, and the person is not identified, that what could be done, I don't know if that's what, that you could bring them into a room with the witness and maybe have him handcuffed. Well, that is out of the question. I don't know. I don't think that is right. I don't think that you said. I was in an ID parade that was very professionally done by an inspector in Four Roads Police Station. Now, if the witness is not identified, although they wish, where the confrontation is concerned, they normally take them into a public place. I did one where the guy was taken, the accused or suspect was taken at KFC. And he sat among other customers. And then the victim was tried, said, listen, you can walk around, and if you see him, then you could point him out. That is what the confrontation is all about. So that was done, and I'll tell you something, witnesses are very afraid now, they're scared to identify anybody at all. So the police might arrest you, or suspect, they call them. I saw one where the fellow just came in and they numbered them during the ID parade, and he just glanced around like that from 1 to 9, and he said, no, the man is not there. I could tell that he was afraid. You understand? When the ID parade is done with 9 persons, I went into the station and I spoke to the suspect, and I said, you're about to go on an ID parade. Did you agree to this ID parade? And he said, yes. The lineup for the ID parade is that all of them must be of similar height. The clothes must be similar. Because the one that I went to, the guy wasn't a stupid boy. When they lined up, he had on a 3/4 pants, and all of them, they were in long pants. And before I could tell the inspector, I said, listen, we have to get this guy to change his pants. He indicated, but sir, you know, I've noticed that they're all wearing long pants, and I have on a 3/4 pants. So he knew what he was doing. He was the only one in slippers. The others had on shoes. And he said, sir, you know, I am only one wearing slippers. So and I said to them, he's perfectly correct. All of this has to be done, because if he only in slippers and the others have on shoes, if he was the only one in a 3/4 pants and the others had long pants, he would have been easily identified. So that's the way it is done. The confrontation, as I said, is done in a public place. where they take you into a public place and you sit down with the public, and he will walk around, and if you have to point them out, you point them out. So I was interested in those 2 points that I wanted to talk about.
I believe you are about to be cross-examined by Member Vieira.
No problem.
Mr. Ascarelli, you're a very experienced Justice of the Peace.
Well, this year will make me my 19th year.
Very good. And so you would agree with me that certainly with the identification parade, the Justice of the Peace is like a referee to ensure that it is conducted fairly.
Yes, sir.
Now, my question is this. Not all Justices of the Peace have your many years of experience. Do you, as a body, as a profession, get investigative training?
We don't get investigative training.
Do you get any training in criminal practice and procedure?
No, sir.
So, would you say all Justices of the Peace may be as astute as you are in discerning the slippers and the three-quarter pants?
I would like to think so.
In the off chance that we're disappointed, do you have any recommendations in terms of what support we can give to the Justices of the Peace to ensure that your role, the very important role you play in this legislation, you meet that role?
Well, we have been asking to meet with members or the Attorney General or whoever. It's important that we meet with them, because what happens is that they are appointing Justices of the Peace and we don't know anything about it. At present, there are about 168 Justices of the Peace. And as an organization, we have been asking that when you appoint these Justices of the Peace, at least you should let us know. We don't know anything. We don't know how they go about appointing them now, because we have training sessions for Justices of the Peace. At our meetings, we have a meeting every second Sunday in every month. And at our meetings, whatever training we can do to the limited amount of Justices of the Peace that we have, we try to train them. We know we have some new ones who just came, and we have training sessions.
Who's doing that training? Is it the older Justices of the Peace?
The older Justices of the Peace, we are doing the training.
But are you getting sort of, for example, seminars or training from experienced attorneys, from maybe the judiciary, anything like that?
At some of our meetings, we have invited attorneys to be present. And an attorney, I'm trying to remember his name, but he came especially and he explained about the identification parade. As a matter of fact, he wrote a little paper on it for us, and we have that.
Mr. Ascarelli, I know you have to leave us shortly. I want to thank you for being here and for making your contribution. I undertake to bring your submissions to the attention of the Honorable Attorney General. I'm sure he'd be happy to meet with the association, particularly in the context of this particular bill and some of the other issues you have raised before us.
Thank you, Mr. Chairman. And we have written to not only this Attorney General, the ones before him and the others, and we've been asking them for meetings with them. And so far, we are not successful in meeting with them. So I'm hoping that maybe something might be done, or something could be done. Again, thank you very much, Mr. Chairman.
Before you leave, Senator Member Thompson, IE, has a question she'd like to pose to you.
Mr. Ascarelli, in respect of the training, following up on what Senator Vieira asked you, have you, as a body or association, had training, like, for example, from the Children's Authority in respect to child rights? How you should treat with children?
No, ma'am, we've had no training with the child's rights, but I am very involved with the CPU, the Child's Protection Unit. You know, when they have to do statements and I have to take that they have taken statements that I have to authenticate. I am called upon by the police a lot, especially I deal with the CPU, the Child's Protection Unit, but we have had no training where that is concerned.
All right. Thank you.
Thank you very much, Mr. Askarali. You're free to leave.
Thank you, sir.
I want to now invite my colleague, Member Cox, who has a question for the prison service, then my colleague, Member De Freitas, and then Member Vieira, and then we would go to the Children's Authority. We've received your submission. In the main three areas you have addressed, the theme in your submission is a request for the extension of the provisions in the bill to offer the Children's Authority and its officers and representatives some of the protection that is being offered in several areas of the bill. And then you also address a specific technical issue relating to, let me just make sure I get it right, under 12X, the issue of psychological assessment of potential child offenders. So I'll invite you to just highlight for us the key areas of your written submission after we've had the opportunity to hear from the three members.
Hi, good afternoon again, and thank you very much for your submission. One of the major problems that exists in the Trinidad and Tobago Prison Service is the overcrowding at remand yard. Would you agree that the passage of this bill will assist in this overcrowding? And if that is the case, then in what way?
Thank you, Madam Senator. We expect once the passage of the bill and the evidence begins to flow, we expect that the population will go up. However, it may not be the unconvicted population, so because the matters will be going through the court faster, so you may get more convicted persons coming into the environment, which then would reduce the mandate population. As I said before, the mandate population is the challenging population for us because the fact is that they don't know how many more years they will have in our custody. So while we expect an increase in the population, I'm not certain that it will be in the remand population. As far as the remanded population goes,
Yes.
right, I said we now at 58%.
Right.
However, with the passage of the bill, we expect that we'll get more convictions at court,
Yes.
so that the convicted population will go up.
But remand population should go down.
Should go down, yes.
Okay, thanks.
Thank you. Member De Freitas.
Thank you, Mr. Chair. Good afternoon again. This may seem like an unorthodox question, but I promise you, there's a reason I'm asking it, and this is really to Mr. Peterson, because I'm really trying to just get some information to clarify some thoughts in my head from practitioners within this sphere. So I asked the first question, do you trust the judicial system as it is right now?
Senator, you're correct, it's unorthodox. Yes, I do. Well, I trust the system. Are you referring to the efficiency of the system, the integrity of the system?
The way the system is set, because it's set up in a particular way when you're dealing with an accused or a trial in general. So you have prosecution, defense, judge, jury, and so forth. So that model,
Yes.
I would say, of justice.
Yeah.
I'm assuming once you're in the legal fraternity, you learn about that system
Yes.
and therefore you trust that system. Right, so the reason I'm asking that is because we're dealing with the witness anonymity order. And in the bill, it speaks to the application being made to the court. So just for my clarification, because I have something in my head, When you hear that, who is that application being made to? Let's say by the prosecution. It's to the judge, correct? Or the magistrate,
Judge or the
whoever
magistrate, yes.
right. So far, in speaking about the witness anonymity order, I'm realizing that there's certain things coming forward, and this is concerns in relation to something that I assume is an entrenched right when dealing with trials, which is the right to face your accuser, and also the possibility of the witness being not credible and making stories up and whatnot. But to me, when I read the bill and how it treats with that order, it speaks to the decision to grant such an order being done by the magistrate. Now, if you trust the system, then it means that you trust that the magistrate, in following the bill, would not just grant that order, to use the word willy-nilly.
Yes.
They take into account a lot of factors,
Yes.
one of which is the right to face your accuser,
Yes.
and two, the credibility of the witness, amongst other things.
Yes.
So it seems to me that the bill takes care of a lot of those concerns by the mere fact of using the process, which is as old as trials themselves, which is the judge's discretion.
Yes.
And I want to assume, and I made this point in the debate itself before it came here, that if you trust that process and you trust that the judge will always do the best that they can given the information that they have. But the beautiful thing about the bill is that it takes into account human error.
Yes.
So much so that the judge can revoke that order should new information come to them. So given that that is what is happening in the bill, do you still have those concerns, knowing that a judge will take into account all of the entrenched rights that are there before and everything that you've said before and makes a best scenario decision based on the information that he has? And the way this is written, it's already case by case. So you don't even need to limit. It's already case by case because, as you all know, every case that comes before the court is unique.
Yes.
So it has to be case by case. So do you think?
Yes, Senator. I now understand the context of the first question. And that is why I said that the anonymity order would be the provision that is going to attract the greatest attention and disquiet among us all. Because historically we are accustomed to facing the accuser. But your point is well taken, if I could say that, and I say it with the greatest of respect, that the order would be decided. You have to apply for an anonymity order. You have to justify it. You can't just come and say, I want an anonymity order. You have to demonstrate there will be almost like what we call a trial within a trial, just like we do for confessions. When a confession is challenged in a trial, there's a trial within a trial, and they hear all a trial may have 10 witnesses. One witness speaks to the confession, they will break away into a trial within a trial, and they could have 15 witnesses giving evidence on that confession as to whether it's voluntary or not. Similarly, with an anonymity order, one would apply for it, they will go and demonstrate in a trial of the issue as to whether such an order would be made. And the magistrate wouldn't grant it lightly, the judge would not grant it lightly. They are going to investigate and interrogate the circumstances and the requirements as to why you need an anonymity order. And it's nothing new, and that is why I said, and I will come to say where my area of not discomfort but of pause is the question coming from Senator Saddam Hussein a while ago. When you apply for an inception of communication order, that is usually done ex parte, you go to a judge and you justify the need for it. It is done. You don't even know that you're being intercepted because you cannot be alerted. Under the financial legislation with respect to tipping off, you're being investigated financially, you're not tipped off, all those things. You go behind in an ex parte position, get an order from a judge, but you have to justify it. And that safeguard exists in the Interception of Communication Act, where an order to intercept is given. If you no longer need it or new information and all of that, you have to destroy the material or it could be revoked. So that applies in the same Section 15 application under the Evidence Act to put in the witness's statement and to stand as his evidence. You have to apply and justify why you should be granted a Section 15C order. So those safeguards are there. And that same kind of safeguard will be transposed into the anonymity order. The only area that I have some pause that I have not been able to clearly work out in my mind is a question coming from Senator Saddam Hussein with respect to how do you have the anonymity order, have the bad character avenue where you could attack the witnesses' bad character to show the kind of person who is now making the allegations against this person at trial without, how do you avail yourself of the bad character challenge without disclosing the identity of the witness. That is the only area where I think we have to have some tweaking and pause about. But your point is well taken, that it wouldn't be granted willy-nilly. You have to demonstrate to get that, and that already obtains, that regime already obtains in the interception of communication and the Section 15 provision.
Member Vera and then Member Hussein.
Thank you, Chair. Deputy Commissioner Clark, I want to thank you for your submissions because even though, as you pointed out, the bill has limited application to the prison service and that in the main you're supportive of this legislation, you raised 2 points that intrigued me. The first one was you said the new procedures for identification of suspects, the proposed witness anonymity orders, which will boost prison officers who face threats daily in their work environment. So I get from this that you're supportive of the witness anonymity orders for prison officers. Could you expand a little bit about this so we could get some meat to the submission?
Senator, as you know, prison officers, many prison officers have been killed in Trinidad and Tobago over the last few years. And some of the challenges we face is the issue of threats against prison officers. Many times in the normal course of their duty, prison officers have to take action in terms of disciplinary matters against some of our charges. In some cases, these matters come to court and the officers' lives are threatened. In many cases as well, once it gets to court, as you know with the disclosure and so on, the address of the name and address of the officer is disclosed to the defense and in court. This then brings a lot of fear in the environment to the officers. So if the officers can give the evidence in court anonymously, then of course that will allow some of the matters to be better heard, to be brought to trial, so that the officers' safety and security will be better addressed once they are allowed to testify in that manner.
Right, so this is a very real risk that you live with in your work environment.
Continuously.
My second point, you raise concerns about children committed to rehabilitation centers. Could you expand on that, please?
That was directly as relates to the appropriate adult persons coming to visit. Again, going back to what Mr. Ferret had indicated, attorney or police persons come to interview children under the age of 18 without having the necessary appropriate adult present. That is, of course, a concern for us.
Thank you.
Sure. Member Hussein.
Thank you very much, Chair. Senior, I just have another question for you. When you started off your submissions, you spoke about the use of photographs in assisting the witnesses to identify the relevant suspect. Now, Senior, we have heard submissions from the DPP with respect to this matter that photographs should only be used in certain circumstances. And I want to get your view, wearing your defense hat, of course. If the suspect is in custody, do you think, in light of the fairness of the identification procedure that has to take place afterwards, whether or not photographs should be shown to the witness prior to the identification procedure if the suspect is in custody?
No, I saw them as alternatives. I thought you use the photograph, the mode of photograph as the mode of identification. If you intend on having an ID parade, which will be the best process, that's the first best step, the formal tradition, what I could call the traditional ID parade, then that is the first best practice. If you don't, I always saw the photograph identification by use of photographs to be an alternative mode of identification.
Because my interpretation from reading the bill is that the photographs are not one of the identification procedure, because when you look at 12E of the bill, it sets out 5 procedures, which is video, then the identification parade, then public place with consent of the suspect, then public place without the consent of the suspect, and lastly, confrontation.
Yes, but you see, all of these, that's why I thought it was a mode of identification. It may be a matter of drafting, but if you notice, all of these presuppose the custody of the person. So you have ID parade by video, you have the person to be done by video. By public, you have the person to take into the public with their consent. You have all of these presupposes the physical custody of the person. What I understood the photo identification mode to be is where you're investigating, you don't yet have the person nabbed, but you need to get to the identity of the person that you're pursuing. Then you use the photos. Because these modes in 12E presupposes physical custody of the person.
Because I think if it will be, a defense will have a field day
Yes.
if you show the,
Yes.
the witness photographs before you conduct the
Right,
parade.
because once you use the photographs, you'll have a difficulty thereafter mounting a parade, having shown them the photographs. So what I could think you could be employing subsequent to that is I'm looking for the phrase, we discussed it, confirmation, verification. Right, verification, a verification process. And the verification could obtain in 2 ways. The person may identify the person by photo and say that photo, but they may not know their name. So they could verify that this is the person I've been referring to as Baba Boy, for example, to use an alias, or in a recognition situation where I know Baba Boy for 20 years. When they hold Baba Boy, whose name is John James, he will then have to verify that the Baba Boy I spoke about is this person who is John James.
Okay. Point taken, Senior. Thank you.
Member Thompson, aye.
With regard to vulnerable witnesses, who are vulnerable witnesses, and their eligibility for special measures, we took in A, the first category, we looked at the age. The legislation speaks about the age or immaturity of the witness. And it goes on physical disability, trauma, fear of intimidation, the witness being a virtual complainant. But the Youth Justice and Criminal Evidence Act 1999 was amended by the Coroners and Justice Act 2009, I believe it was, what came into force in 2013. And the effect of that is that there's automatic eligibility for a child. So once you're under 18, that's one. Now also, if it is an offense involving a weapon, like a knife or a gun, you know, that's an important consideration as well. That makes it eligible. Do you think that our legislation would be improved by actually specifying that instead of having it broad as age or immaturity of the child, that you're automatically eligible, and then you have the inquiry? Mr. Legal Aid, don't look on your right. I want you to, Mr. Benjamin, if you may. Yes. Sorry, Mr. Trinidad Authority,
Okay.
Sorry. No, I saw him looking across, but I
Mr.
really would like. Yes,
Thank you.
No.
I was waiting on a good chair to
sorry.
let me know when to start.
The member did, in fact, started off directing to one person, and we landed by you, which is where we plan to end up anyway.
And which is where, thank you, Chair, I plan to start. And I know we have an order in the document, but because of the seriousness of the discussion in relation to the anonymity and that area, I want to start there. And I want to preface by saying off the bat that children should fall into a category even without having to make an application to the court. I think that once you're a child and you are in relation to any form of abuse, that you fall under that category without any application to a court. Additionally, we are looking for an extension in relation to persons who may make reports in relation to abuse of children. Over the last 5 years of our operation, one of the greatest challenges that we have been facing with is reporting of abuse. Not just reporting of abuse, but follow up and follow through to prosecution. And so what we are seeking to do via this important piece of legislation here is to include persons who may make an application or make a report to the Children's Authority about an abuse. And we're looking at it from two perspectives. We are looking at it from one perspective that that person has the cover, right? And so we made some indication, medical profession, educators, the neighbor, or the father in a home, or the mother, or whomever it is. But the second part of this is that if this person should be called to testify, that again should have the cover of this act, where that if you are to testify about an abusive situation through our forensic interviewing process, you can have that cover. Yeah? Mr. Chairman, we have established by the Children's Act our forensic centers, where you can have a forensic interviews, the two-way mirror, the recording, the video conferencing, and stuff like that. But there's been a reluctance to use it thus far, whether or not it is for fear of newness or it is untested so far. But we have within our purview at our assessment centers that ability. And so we want to be able to utilize that facility to record these statements, yeah? And to be able to give the persons or the child or children that level of protection by utilizing that. As it stands, the CPU or the Child Protection Unit of the Police Service work hand in hand with us, and they are present to record these statements, yet we're having challenges with it going forward as evidence. Huh? Right, and so with me today is Charlene Jagannath, Legal Services Manager, who has ably pointed out that under the new clause 12Q, that is where we are seeking to have an extension, not just investigating officer, but the Children's Authority of Trinidad and Tobago added. Also, under 69, what is this here? Yeah. On the recording of interviews, the new clause 12Q. And so under this area of special measures, we are seriously advocating for that inclusion, for the protection of children. I would now move to the first area on our submission, which is that of provision for recording of interviews.
Okay, Chairman, and we gather from the written submission that you are seeking to have the Children's Authority included in a specific section of the bill.
Correct.
And in the opening, I referred to that because you believe that where the authority itself takes statements, and you just alluded to it, video recorded statements, it should be covered by this bill.
Correct.
And okay, so I will now ask you to go to your second submission, which deals with 12X of the bill.
And so for this point, I will ask our Legal Services Manager to guide us through, and I will assist as needed.
Ms. Jagannath?
Yes, please. I'm grateful, Chairman, members of the committee. The point to be made in relation to the proposed section 12X, which speaks to, it prescribes procedures for the taking by the police of oral admissions given by accused persons who are giving statements. What we see here, the reading of this section actually assisted us in identifying a lacuna in the law that may that is very applicable to our process, insofar as we are straddling both, as the agency with responsibility for child protection, there's a straddling of that area between the civil arena, the public law element in which we seek care orders and wardship orders from the children court, and then there's the other element that is dealt with by the CPU, which is the criminal prosecutions of those matters. Now, so that this straddling will take place in relation to pretty much a matter arising out of the same case, the same report being made, two different agencies doing separate investigations for that report. Now, our investigation would include the civil investigation. That would involve both our clinical interviews as well as in-depth assessments of both the child victim and the potential perpetrator of the act. And during that process, in many occasions, we have situations in which oral admissions are made. Nowhere in the law thus far have we seen any provisions which treat with the admissibility of that evidence taken through the civil investigation process in the criminal proceedings that are related. So, and we understand that it will, of course, be a contentious issue. In other jurisdictions, there are different approaches that are taken. In the UK, for instance, there is a provision for joint case management by both courts. And so what we're just asking at this point is that consideration be given, whether it's in this act or perhaps another law, but there is need for some regularization of that area. How do we treat with oral admissions made to the authority and the admissibility, which is critical to the prosecution of the related criminal offense? That's the crux of the submission in that regard.
Right, thank you very much. And I know at least one member has already
Yes.
turned in my direction and said this is going to be very contentious.
It would,
But we
yes.
appreciate the submission. Your third submission, as I alluded to earlier, deals with, similarly, the extension of provisions in the bill, and in particular 12AA and 12AG, to the proceedings of the Children's Authority. Is there anything in that submission you would like to highlight beyond what is in the written submission? We understand we've also heard from the Trinidad and Tobago Police Service the need to have those provisions or similar provisions extended to cover some of their officers.
Yes. So with respect to Section 12AE, the special measures, yes, relation. Now, a lot of this already exists by virtue of the Children Act, Part 13 deals with the application, where again the court has the discretion or the jurisdiction to hear applications which would allow the court to put in place certain special measures in place to protect the vulnerable witnesses. We are saying that it would be prudent to include a provision that would cover also victims of things like spousal abuse, which we also see coming up in our matters. Yeah, that's the crux of our argument, yes.
Okay. I see members nodding in agreement and maybe happiness. I don't see any of my members trying to get my attention, so I want to proceed to thank the three groups which are before us today: the Legal Aid and Advisory Authority, Senior Counsel Gilbert Peterson. I was watching the clock. We've cost you maybe an hour and a half, but
I will apply the published rates by the judiciary.
well, I was about to say that you have extended to this country a lot of public service, and we appreciate it, and we appreciate the team you have brought from the Legal Aid today.
Thank you, Mr. Chairman.
Mr. Clark, thank you very much for taking time. We know you have a lot of work to do. We appreciate having your team here with you, your legal officer who has provided support to you. On behalf of the committee, we want you to extend to Mr. Wilson thanks for his service, and we wish him well in his retirement. Mr. Benjamin and Ms. Jagannath, you've been before various committees of the Parliament. We appreciate your contribution, your written contribution, your submissions before us today. And if there is anything all three stakeholders wish to contribute further, you can do so in writing. And to the members of the public who are listening now and viewing on television and who would listen later on and view the rebroadcast, we thank you very much for your participation. Members of the committee, representatives from the Office of the Attorney General and the Chief Parliamentary Counsel, and of course the Secretariat provided to us by the Parliament, and of course the media. I see Mr. Douglas in the corner there. Thank you very much for covering and for reporting fairly and accurately on these proceedings. Thank you very much. This meeting is adjourned.